Good evening, everyone, and welcome. Thank you for joining the first of B.E.A.C.C. series of webinars on the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, or in short, CPTPP. I'm Leela Panikar from TREES. We are the Secretariat for B.E.A.C.C. B.E.A.C.C., which stands for Biodiversity, Environment, Agroecology, Climate Change, Habitats, is the environment cluster of the CSO Platform for Reform, a coalition of more than 100 civil society organizations focusing on institutional reforms for a better Malaysia. We hope this will be a great opportunity for all of us to learn and share about CPTPP and its impact on environmental policies. Without further ado, please allow us to introduce Mr. Syed Munawar, a freelance TV host, content advocate, and trainer. He will be the moderator for tonight's session. The floor is yours, Syed. Thank you.
Thank you very much, Leela, and I would like to thank B.E.A.C.C. and TREES for inviting me to host the session. But before we move on, first and foremost, I think as far as our targeted audience is concerned, I suppose majority of the rakyat, they just couldn't be bothered about CPTPP because CPTPP is considered to be complex and confusing to many, and perhaps many would just prefer to ignore it since, as the saying goes, ignorance is bliss. You know, what you don't know won't hurt you, and this is a kind of bewilderment that we actually must address. And I think that's the main main objective of our Sembang Santai for this session. Let's just look at one MDB for an instance. As bad as it is to our country, I doubt that the rakyat actually felt the hurt, felt the burden of paying back all the dues. You know, I attended a number of seminars regarding CPTPP before, organized by the NGOs and CSOs, and I've heard a lot, but still there are some areas which I'm not familiar with. What more if I were to come up with a counter argument? Nevertheless, I had a chance of interviewing a minister, our minister who's in charge of CPTPP, and I posed questions which I gathered from NGOs regarding CPTPP, and that particular minister simply just brushed it off and saying that his ministry has already taken into account all the CBAs, the cost benefit analysis, and extensive consultations have been done across the board. But then just 2 days ago, I got a chance in interviewing another minister, and this particular minister acknowledged that there is in fact some red flags regarding CPTPP, and he only got to know about it upon consultation with an NGO, namely known as Forum Kedaulatan Makanan. So this particular minister acknowledged that there are some concerns when it comes to agriculture and food security, and it's a good thing that this minister said it out loud on national TV live, promising that he will look into the matter. So, but then these two incidents says a lot about the levels of consultation done by the respective ministry. You know, how much and how extensive were the consultation done prior to signing and ratifying CPTPP, and we got to know that CPTPP was signed just a few days before nomination day, and now leaving us with only 6 months if we were to withdraw or even come up with some kind of relief. So how can it be that only after signing there are still red flags, and albeit relating to one ministry or one portfolio? What about all the other ministries? Well, perhaps maybe one would say this particular minister is a new minister, and he has a tendency of going against his predecessor. But then what about the KSU? What about those who are sitting behind the CPTPP desk in that particular ministry? So I, for one, have a lot of questions, and I believe that all our participants have many more. And in fact, we have our speaker. Our first speaker is Sanya Reed-Smith. I would like to welcome Sanya. Sanya is from Third World Network. And Sanya is worked in Third World Networks in KL before during the FTA negotiations. She analyzes the impact of FTA on Malaysia's economy. And currently she is working in Third World Networks Geneva office and Third World Networks International Secretariat in Penang. So without further ado, I'd like to invite Tanya. Please, Tanya, the floor is yours.
Thank you very much, and thank you to the organisers for inviting me, and to you, the participants, for making time to join this webinar. I may have to turn my video off because the internet is a bit slow where I am, but there's a PowerPoint for you to look at that the organisers, I think, are going to kindly share. So I just wanted to give you a bit of background on the CPTPP on the next slide. So it started life as the Trans-Pacific Partnership Agreement, on the next slide, I think, slide 2. And Malaysia joined those TPP negotiations in 2010. Then those negotiations concluded in 2015, and basically it was a US free trade agreement, a standard US free trade agreement with some new additional restrictions on Malaysia's ability to regulate in policy space. So that was under the Obama administration. It was signed in 2016, including by Malaysia and the countries you can see listed there. But then President Trump was elected in the US, and he decided that he did not want to ratify it. He did not want it to come into force for the US. And so if it didn't come into force for the US, it could not come into force for anyone. So the remaining 11 countries had to decide what to do, and they temporarily suspended 22 of the more than 1,000 provisions in the TPP, including some of the worst ones that made medicines more expensive, for example. Then they renamed it Comprehensive and Progressive, and they signed it in March 2018, including Malaysia. But it doesn't come into force until countries ratify it. So you can see there at the end of 2018, some of those countries had ratified it. It came into force for them in 2019 for Vietnam, 2021 for Peru. And then for Malaysia, as the moderator said, the previous Malaysian government ratified it at the end of September 2022. And then it came into effect 2 months after that. So on the 29th of November, 2022. And in between, you remember there was an election, there was a hung parliament, there was no Minister of Trade and so on. But basically, the text of the CPTPP is what was agreed in 2015, and then some of those provisions were suspended in 2018. But of course, the world has changed since then. We've had a COVID pandemic, climate change has got much worse. So the question is, do those CPTPP provisions from those days still suit Malaysia today and its environmental laws and policies? So on the next slide, you'll see that the CPTPP has 30 chapters. Most of them are not what you may think of as trade, about exporting clothes or electronics or palm oil. Most of them are about Malaysia's other regulations, whether it's intellectual property laws or environment regulations or how the government buys things or its regulations of its government-linked companies and so on. So today I'll just be focusing on the investment chapter. And if my sound is no good, somebody tell me and I'll switch off the video. But we're going to have a second webinar, I think, on the 19th of January, which will look at the impact of some of these other CPTPP chapters on the environment. So today's one will focus on the investment chapter and its implications for the Malaysian environmental laws, policies, regulations, and so on. But those of you who are interested in the impact of the CPTPP, for example, on biosafety, biopiracy, traditional knowledge, plastic waste, farmers' rights and seeds, and so on, that's more going to be covered in the second webinar on the 19th of January at the same time about some of these other CPTPP chapters and their impacts on other environmental laws and policies. And there may be a third webinar towards the end of February on the impact of the CPTPP on Orang Asli and Indigenous peoples, because that's a whole other set of problematic provisions in addition to those in the investment chapter. So, of course, the investment chapter of the CPTPP and other CPTPP chapters have impacts on many other sectors, including farmers, health, COVID measures, Orang Asli, and so on. But today we are focusing on the impact of the investment chapter on the environment in Malaysia. So in the next slide, let's look at what are the actual provisions in the CPTPP investment chapter. So this chapter is about protecting the rights of foreign investors. So it has a broad definition of investment that gets the protection of this chapter. You may think of foreign investment as something like a factory in Malaysia by a Japanese car company. Yes, that is protected as an investment in this chapter, but so are many other things like companies, shares, contracts, licenses, permits, other property, future profits. These are all protected in a non-exhaustive list and also other things by this chapter. And it's investments by an investor of another party. So a party is a country which has ratified the CPTPP, and we saw those on an earlier slide. So you may think, oh, well, it only protects, Canadian companies in Malaysia, but not US companies in Malaysia because the US is not a CPTPP party. Because remember, the Trump administration didn't want to ratify it, and the Biden administration has not either. But the way that it's defined in the CPTPP means that companies which have a branch or a subsidiary in another CPTPP country is also protected by this chapter. So, for example, a US company, a US mining company that has a branch in Japan or Australia or Singapore is an investor from a CPTPP country and gets the benefits of this chapter. So this chapter is all about protecting foreign investors. And it is strictly binding on all levels of government. So that's the federal government in Malaysia, the national government, as well as state governments, say the Kedah or Penang or Sabah or Sarawak governments, as well as local governments, like Petaling Jaya, for example. So all those levels of government must comply with these provisions that I'm about to explain. One of the things that is in this investment chapter are what we call negative list restrictions on the ability to require foreign investors to do things. So negative list means Malaysia cannot require it in any sector, except those where it listed exceptions in 2015 that were agreed to by all the other CPTPP countries, and they're in Malaysia's annexes 1 and 2. And this actually applies to investors from the whole world, so not just those from CPTPP countries. And it says that Malaysia cannot require investors to do a number of things, including it cannot require foreign investors from the whole world to use Malaysian inputs. So for environmental reasons, you might want foreign investors to use locally made inputs because they're transported less far, or to support your local industries, say in a green economy. And it looks like cannot require foreign investors to use domestic services like banking services or consulting services or electricity and so on. The second main one is that Malaysia cannot require foreign investors to transfer technology to Malaysian companies. So, for example, in the climate change context, you may want foreign investors to transfer technology to deal with climate change, whether it's making solar panels or windmills or less polluting technology, to Malaysian companies, whether they are government-linked companies or the private sector, so that Malaysia can reduce its emissions or cope better with climate change and so on. Because often if you leave it to the companies, they won't voluntarily transfer technology. So especially say in the mining or natural resources sector where the investors are always going to come anyway, you may want to require them to transfer that technology. So again, Malaysia cannot require that except in the sectors where it has exceptions listed in 2015 in its annexes. There is an exception for conservation, not environment generally, but only if you meet a very difficult standard, which is harder to satisfy this test than even in the World Trade Organization, where governments failed at 86% of the time. Now, of course, these provisions that I'm describing also apply the other way. So this also restricts the other CPTPP governments. But here, of course, I'm focusing on the impact on Malaysia, so I'll use Malaysia as an example. Then there are the third one that is restricted on a negative list basis is Malaysia's ability to set maximum royalties that have to be paid under voluntary licenses. So this means, for example, if a Canadian company was giving a license to a Malaysian company to make solar panels, or a Japanese company was doing it to make solar panels, and Malaysia was worried that the Malaysian company would have to pay too high royalties, for that patented technology or that industrial design protected technology. Before the CPTPP, Malaysia could set those royalties at an affordable rate to make sure that the Malaysian company could afford it and the Malaysian consumers who are buying the solar panels or whatever could afford it. And this can be important, for example, if you remember the Montreal Protocol about chlorofluorocarbons that were causing the hole in the ozone layer, and the Montreal Protocol said you're not supposed to use these CFCs anymore. So in India, the manufacturers wanted to shift from using these CFCs to a more environmentally friendly substitute, but the substitute was patented, and the patent owner required Indian companies to pay $25 million in royalties when it should have been $2 million. So India capped, they set a maximum in royalties that Indian companies have to pay for technology to foreign companies, and they capped it at 5%. when India removed that cap, the royalty payments increased by 500%, and now it's like 33% of their FDI flows and so on. So if governments don't cap it, the royalties can be very high and unaffordable for local companies and then consumers who need that environmental technology, for example. So other developing countries in the past have also capped voluntary license royalties, but under the CPTPP, Malaysia cannot do this except in the sectors it listed in 2015. Again, there's an exception for legitimate public welfare objectives, but it's not clear that includes environment. And again, you have to pass a test that the easier to pass version governments failed 86% of the time. Then we move to what is called fair and equitable treatment. Sounds very nice. Why don't you want to treat the investors fairly and equitably? But this has been interpreted in some cases, in some past disputes, as a standstill on your laws and regulations. So no new laws, no new regulations, no changing them if it harms the foreign investor. And the United Nations has said that this standard is nearly impossible to achieve. Because if this is the interpretation that is followed in the CPTPP, it would really restrict Malaysia's ability to regulate. For example, if you find a chemical is dangerous for the environment and you want to ban it, maybe you can't. If because of climate change, you need to have a new climate act or you need to amend your existing laws and regulations, maybe it violates fair and equitable treatment. So we don't know how this will be interpreted until there's a case, but based on some of the past ways it's been interpreted, it has been interpreted in some of these cases as a standstill. It's the most common violation found in these kinds of treaties. And you could not schedule any exceptions to it. So Malaysia could not have any annexes with exceptions in certain sectors and so on. Then one of the other general obligations you can see there is expropriation. So this is saying that if the government, the Malaysian government, directly expropriates, so for example, it wants to create a forest reserve, and to do that, it has to take over somebody's house and their private land. So the Malaysian government becomes the owner of that land, and that's called direct expropriation, plus interest at a commercially reasonable rate. Maybe I stop my video because I think my internet is bad. Okay, and that can be compound interest. So this expropriation, when it's direct expropriation, it means the Malaysian government becomes the owner of the land. Say it wants to create a forest reserve on where somebody's house is. But the CPTPP also says there must be this fair market value compensation for indirect expropriation. And indirect expropriation can be reducing the value of the investment, which remember was broadly defined to include, the profits they expected to make, their permits, their contracts, their other property. So if you have reduced the value of that, even though the Malaysian government did not become the owner, and it's not just for land, it's all those other things that I mentioned were an investment, then that can be expropriation. The Malaysian government has to pay fair market value compensation, plus interest at a commercially reasonable rate, and so on. So this also, there is an exception in an annex, again, for legitimate public welfare things that include the environment, as long as they're non-discriminatory, but in rare circumstances, even these could still be expropriation. So the first problem is that this is in an annex, and in some past cases under US free trade agreements, the tribunals have ignored the annexes. And the second problem is, even in rare circumstances, this could again still be expropriation. And every tribunal is ad hoc. They each think they are the rare circumstance. So far in the 45 cases I've checked, rare circumstances, that wording has never yet caused an expropriation claim to be rejected. So how is all this enforced? It's enforced through something called investor to state dispute settlement. So this allows the foreign investor, say the Canadian mining company, to sue the Malaysian government at an international tribunal. And the Malaysian government has automatically consented to being sued in all cases except tobacco control, which we'll talk about later. And the investor can get unlimited monetary damages and compound interest, which can be compounded every month from the date the government took the action. For example, it didn't allow a mine, or it banned a dangerous chemical, or something like that. So the CPTPP did suspend some of the original TPP's investor to state dispute settlement, but only for investment contracts and investment authorizations. So that leaves 94% of ISDS cases, including to enforce the provisions on this slide, that are still possible under the CPTPP. So some of these awards can be very big. You can see on the slide that there are 17 known cases and maybe more that are unknown because they're not all public, in each of which the investors got more than $1 billion in damages. So for example, you can see Pakistan had to pay an investor $5.9 billion, which included $1.8 billion in interest alone, $63 million in legal fees. And Pakistan had just received a loan from the International Monetary Fund of $6 billion with, very strict austerity requirements, which caused national strikes. And basically they had to hand the whole thing to one investor when they lost a case. So even the cost-benefit analysis commissioned by the Malaysian Ministry of International Trade and Industry said that in terms of downside risks, the government may have to prepare and allocate resources to respond to possible ISDS claims. In addition, there can be some indirect impacts. So for example, the CPTPP investment chapter says that the Malaysian government cannot require senior managers and directors of foreign companies to be Malaysians. And this can make it more difficult to enforce environmental laws. For example, if you remember in 1984, there was a Bhopal industrial disaster, a gas leak. And in India, it happened in India, and the Indian chair, the managing director, the vice president, and other Indian managers were jailed for negligence. But the US chief executive officer was charged by an Indian court with manslaughter because so many people died. But he fled to the US and the US refused to extradite him. So it was not possible to enforce India's laws for that environmental disaster on a foreign director or foreign manager because he just ran back to his country. So, this has kind of indirect implications for Malaysia's ability to enforce environmental laws if they want to punish the managers or the directors of these foreign companies, for example, if they pollute the environment in Malaysia or cause some industrial disaster that causes loss of life and so on. Another indirect impact, of course, is if Malaysia has to pay kind of billions in damages under this ISDS, even not for an environmental reason. For example, if Malaysia does some financial regulation that gets challenged through ISDS, then that loss of revenue means that there will be less money to spend on the environment unless environment spending is ring-fenced. The investment chapter, of course, also has other provisions that can be problematic for Malaysia. For example, it restricts Malaysia's ability to do capital controls, which Malaysia used successfully to get out of the 1998 financial crisis in Asia. But these are kind of non-environmental impacts, so we won't talk about that. And of course, this works both ways. Malaysian investors could use this chapter to sue, say, the Canadian government about Canada's environmental laws if they wanted to. So I realize that's a bit technical and a bit fast, so maybe we'll pause here in case there's any clarification questions so far before we get on to examples of how these provisions have applied in some environmental cases. I think you can put questions in the chat, or maybe you're also able to raise your hand.
Yeah, Sanya, there are no questions so far in the chat box, but can I ask you a question instead?
Please.
Yeah, I sense apprehension but on the part of the minister, they are so confident about this, despite the fact that there are all the ISDS happening involving Pakistan. I can see in the slide now. So what do you make of this? Why is the government doesn't have the concerns that you're raising? And I heard some of the arguments coming from the government side is that Vietnam has been an early partner of CPTPP, has benefited a lot from this. So what's your response to that?
Yes, so that's an interesting question. It's true that, these kinds of ISDS and investment provisions have been around for some time. Malaysia already has treaties with some of these provisions, but Malaysia, for example, does not have this kind of treaty with Canada. So this would be the first time Canadian investors can sue, and Canadian investors are the 6th most litigious in the world. They are known to have sued 63 times. It will be the first time Mexican investors can sue Malaysia. And as I mentioned, some US companies can indirectly sue if they have a subsidiary or a branch in Canada and so on. And it also goes further than Malaysia's existing treaties, because these kinds of provisions also appear in bilateral investment treaties and the investment chapter of some other free trade agreements. But when Malaysia has been sued in the past under this, there were 3 cases that we know of. They were brought under earlier Malaysian investment treaties that had a much narrower definition of what gets the protection of these provisions. And it only protected approved projects. So, projects approved by MIDA. So, for example, one of those cases was in the 1998 Asian financial crisis, when I think it was a Belgian investor wanted to take his money out of the stock market, and he couldn't because of Tun Mahathir's capital controls. He sued under this, and he lost under those old treaties because, money on the stock market is not an approved project approved by MIDA. So Malaysia was fortunate in the past that those disputes were under those kinds of narrower treaties, which don't protect such a broad range of investments. But as I explained, the CPTPP protects a much broader range of investments, including, money on the stock market, contracts, permits, licenses, future expected profits. So if the same kinds of cases were run again, then the outcome is likely to be different. Malaysia may not win again. And so the world has also changed since, some of this was agreed, and I'll talk a bit later about some of the countries which are withdrawing. But for example, New Zealand, which has a GNI per capita 4 times more than Malaysia's in terms of its economic size or its richness, they were still worried about ISDS under the CPTPP, and they tried to exclude it bilaterally with different CPTPP countries through side letters, for example. And so the concerns about ISDS have increased since 2015, and a lot of governments who have been sued under ISDS have learnt the lesson and no longer agree to it or withdrawing from these kinds of treaties, and I'll talk about that a bit later. But your other question was, Vietnam's doing so great out of the CPTPP. And so it depends what exactly they're talking about here with respect to Vietnam. So, for example, is it that Vietnam's exports are increasing? Or is it that Vietnam is getting more foreign direct investment? So there's actually a link to a study I give at the end, which shows that although Malaysia can increase its exports under the CPTPP, its imports will increase by more. And so Malaysia's trade balance will actually worsen. Now, that may not be the same for Vietnam, depending on its starting tariffs. And also, for example, Malaysia agreed to remove tariffs on 100% of imports coming into Malaysia from other CPTPP countries, whereas Vietnam only agreed to remove tariffs on 97% of imports coming into Vietnam. So they may do better in terms of trade balance than Malaysia. And then in terms of foreign direct investment, we know for example, from the World Bank and from economists that drivers of foreign direct investment are things like if you have a big economy, so, India and China, they'll always want to be supermarkets opening there to sell to a lot of their people. Vietnam, of course, has a bigger population than Malaysia. If you have natural resources like oil and gas, foreign investors will always want to come to take those natural resources. If you have peace and stability, your country is not at war. If you have good infrastructure, your roads and ports are not jammed, your electricity doesn't go off 10 times a day, and you have cheap labor. These are the main drivers of foreign direct investment. And it's not whether or not you have these kinds of provisions like the investment chapter. It's not whether or not you have a free trade agreement. So it's not clear that, this FDI coming into Vietnam is because of the CPTPP. So I don't know if that answers your questions.
Yeah. So there are some other questions coming in the chat box. So can we address a few more, Tanya?
Sure.
Okay. I see that Sunita's question, I would like to combine with Aisha's question as one question. Sunita was asking the impact of these provisions on the advocacy for climate change, and will there be enhancement on our EIAs? And Aisha asking the question, could you elaborate on the benefits of foreign investors using local materials and the impact it has towards our environment?
Sure. So on the first questions about EIAs and climate, that's coming straight after this. So I'll do that in a couple of minutes after this Q&A. And then I think Evelyn Ter may go into it more in the second part with, referring specifically to Malaysia's climate planned policies and things like that. And then in terms of local materials. So, it depends if this is something that is a concern for the environment, that foreign investors are importing the materials from a long way away. It's also kind of a industry issue where you may want foreign investors to use, domestic inputs to give jobs to and business to local companies. So if you want that kind of thing, of course, technically this is not permitted by the World Trade Organization, which Malaysia is part of, but in the World Trade Organization, the dispute settlement function is currently a bit dead because the US is blocking the appointment of the appellate body members. So it's not really enforceable, and there it's only enforced by governments suing each other. Whereas here in the CPTPP, it's also enforced by investors being able to sue if they don't like a requirement to use local inputs. I'm just looking through the chat. There's a lot going on now.
Let's take one more question, shall we?
Mm-hmm. Yes, please.
J. Philip posted 2 questions, but the earlier question will be addressed during Evelyn's session. I take J. Philip's second question, which goes, with US and China trade war ongoing, we have or may have manufacturing collaboration between China and Malaysia. As such, how will CPTPP know or there are any registry in formulated or take care the concerned parties in investment?
Yeah, so as the question points out, with the US-China trade war going on, Chinese companies are looking to invest in other countries. So, for example, that, instead of manufacturing cars in China, maybe they manufacture, and then if they face high tariffs into the US, maybe if they manufacture them in Malaysia, then they can be exported from Malaysia to the US without facing these high US tariffs from the Trump administration and now the Biden administration. So that's something that is happening kind of with or without the CPTPP, right? That Chinese companies are looking to manufacture in other countries where they won't be penalized. I don't know that there is the CPTPP, to my knowledge, does not kind of require any registry. And technically, Chinese investors don't get the benefit of this chapter because they're not yet a CPTPP party. And I'm not sure that China will ever be able to join the CPTPP because a lot of the provisions in it would be very difficult for China to comply with. So China, of course, and Malaysia are in the Regional Comprehensive Economic Partnership, or RCEP, which has come into force recently, including for Malaysia. And that one does not yet have ISDS. And I'll talk a bit more about why that is later.
Okay. All the other questions will be addressed during Malaysian context session with Evelyn. Yep.
So shall we keep going to the next slide? So now you know what's in the investment chapter. On the next slide, slide 5, we're going to look at some examples of how this has worked in terms of impacting environmental laws and policies. So you can see the first 2 examples are about banning chemicals and stuff. The first one was Canada banned the export of PCBs, biphenyls, to comply with the Basel Convention, on transboundary movement of hazardous waste. Canada was sued via this ISDS that I mentioned, where the investor can sue Canada. And these are all occurring under other treaties that have similar provisions to those that I just mentioned are in the CPTPP investment chapter. And Canada was found to have violated fair and equitable treatment, which of course is in the CPTPP, and they had to pay the investor $5.6 million for the lost profits the investor would have made during the 16 months when they were complying with the Basel Convention. So you can see that the government doing something for the environment in order to comply with an environment treaty is no excuse. It doesn't matter the government's reasons for doing it, because it's required by the Constitution, because it's required by an environment treaty, whether it's the UNFCCC or the Basel Convention or the Convention on Biological Diversity. The question is just whether you have violated the investor's rights, as I described them on the previous slide, then the investor can sue using this ISDS. And later we'll talk about whether there are any other exceptions. And so remember, these cases are all occurring under other treaties that have equivalent provisions. And there are known to have been like 1,229 ISDS cases, many of them are not public, against 132 countries under these equivalent provisions in other similar treaties. Then the next one, number 2 there, is Canada banned a chemical for environmental and health reasons. They were sued by ISDS for violating expropriation. And this was an additive to petrol called methyl cyclopentadienyl manganese tricarbonyl, MMT. And Canada banned it because it undermined their efforts to control air pollution and could contribute to the build-up of greenhouse gases, of course, that cause climate change. Canada was sued. This is case number 2, and they settled. They reversed the ban on this problematic chemical. They paid $13 million to the investor, and they issued a statement for the investor to use in their ads saying that current scientific information does not demonstrate its toxicity. Then the example number 3, and some of the, I guess, 3, 4, 5, 6 are about not allowing quarries and mines and things like that. So number 3 is an environmental assessment, an EIA, environmental impact assessment, was done in Canada for a quarry and a seaport, which was about mining the rock and then exporting it from the marine terminal. And it was in a key habitat for several endangered species, including one of the world's most endangered whales. The environmental impact assessment said, this is going to be bad. So the province and the Canadian government rejected the quarry. The foreign investor sued via ISDS. The tribunal found Canada had violated FET, which is also in the CPTPP investment chapter, and had to pay the investor $7 million. Number 4 is again about not allowing a quarry. This time it was a provincial government in Canada that did not allow a quarry because of wetland conservation and water concerns. Again, the investor claimed violations of FET and expropriation, which are in the CPTPP investment chapter. This time it was settled by the province paying the investor $11 million because the Canadian government was sick of having to pay for when the provinces were violating these provisions, so they forced the provincial government to pay it. That's like a state government, like the Sabah government, for example, because it's the federal government that gets sued under ISDS. And then the question is whether, remember these provisions in the investment chapter are binding on the federal, state, and local governments. So if the Sarawak government violates those investment provisions on the previous slide, it would be the Malaysian government that is sued under the CPTPP ISDS provisions. Then if the Malaysian government loses and has to pay $1 billion in damages, can it get that money back from the Sarawak government? Can it, for example, withhold funding to Sarawak? And this has been a big problem in a number of cases, including in Canada and Mexico. So in this one, the Canadian federal government forced the province to pay the investor the $11 million because they said, look, it's the province's fault for violating these investment provisions, and the federal government was sick of paying it. And the question is, if the province or the state, like Sabah or Sarawak, has to pay, do they have a spare few $1 billion lying around in case, they lose one of these cases? Then number 5, this was the Pakistan case that I mentioned, where a provincial government, again in Pakistan, refused to give a mining lease, not for environmental reasons. The Pakistan national government was sued. They found to have violated FET and expropriation, and that's where they had to pay $5.9 billion to one investor. It was an Australian mining company. Then, if you remember the Fukushima nuclear disaster, so after that, the German government looked at nuclear power and said, look, this is not safe, we're going to phase it out. They were sued by the nuclear power company, again alleging violations of fair and equitable treatment and expropriation. They settled by paying the nuclear power company $1.7 billion. Then we get into the hazardous waste examples. So these are both in Mexico, number 7 and 8. So number 7 was a local government not giving a permit for hazardous waste facility because of environmental concerns. They were worried the toxic waste dump could contaminate the water. The state government created a kind of ecological preserve, like a forest reserve, which meant you couldn't have this hazardous waste facility there. The investor sued under ISDS. 1, there was violations of FET and expropriation, which are in the CPTPP investment chapter, and the Mexican government had to pay the foreign investor $16 million. The Mexican government tried to get that money back from the state governments because they said it's the state government's fault, and under Mexican law, they could not force the state government to pay the $16 million, but they did try to get it back from the state government. Number 8 is a similar example, again in Mexico, where the community opposed the hazardous waste facility for environmental reasons. The Ministry of Environment's actions were also found to have violated this investment treaty because they did not allow a hazardous waste facility on a geographical fault line across from a dam and a biosphere reserve, which was UNESCO World Heritage and home to Indigenous communities. Mexico was found to have violated FET and expropriation, which are in the CPTP investment chapter. And Mexico had to pay more than $40 million to the foreign investor, including for the lost future profits that the investor would have made if they could have operated this hazardous waste facility, but they weren't given the permit. Okay, next slide. Slide 6 has a few more examples. So here we look at some of the pollution examples. I don't know if you remember, Chevron polluted the Amazon rainforest, harming indigenous people who were there. And they were fined $9.5 billion by a domestic court in Ecuador, the local court. Chevron didn't want to pay. So they sued Ecuador via ISDS because Ecuador enforced this court decision, and Chevron won. And Ecuador was found to have violated fair and equitable treatment and so on. The ISDS tribunal said the Ecuadorian judge had been corrupt and taken a bribe in order to find that, Chevron polluted the rainforest and had to pay $9.5 billion. And so it was the Ecuador government's fault for enforcing this corrupt domestic court decision, and they're still deciding the damages. You'll see that there's, under the pending cases, there's also a Peruvian pollution case, which is a very shocking one, where a metal smelter polluted the environment around it so badly it was in the top 10 most polluted sites in the world. 99% of the children around it had lead poisoning. There was cadmium 40 times World Health Organization levels, sulfur dioxide 10 times above WHO levels. And the investor was supposed to clean it up. They didn't clean it up. The Peruvian government gave them 2 extensions. And because the Peruvian government didn't give them a 3rd extension, the investors sued Peru for $800 million. The investor lost the first time because they hadn't filled in their paperwork correctly. So now they're suing again, alleging violations of fair and equitable treatment and expropriation, and the case is still going on. But what you see under the Chevron case, and also number 10, is what happens when investors break the law. So number 10 wasn't an environmental example, but what happened was an oil company in Ecuador sold their rights to extract oil without the permission of the Ecuador government, which was against the law in Ecuador and against the contract. And under Ecuador's law and under the contract, Ecuador could cancel their permit to extract oil. So Ecuador did. And the ISDS tribunal agreed that Ecuador had those rights under the contract and under the law. But nevertheless, when Ecuador punished the investor as it was allowed to by its law and by the contract, it was sued under ISDS, and the ISDS tribunal found Ecuador violated the investment provisions, FET and expropriation, and Ecuador had to pay the lawbreaker $1 billion. So this is pay the lawbreaker, pay the polluter, because even lawbreakers and polluters can still sue. For example, if the Malaysian government fines them for polluting or for otherwise violating environmental laws, then the foreign investor can sue them back under ISDS and get paid back the fine that they were fined or whatever the damages for, cancelling their contract or their permit and so on. So how then could Malaysia enforce environmental laws on foreign investors if they can sue Malaysia back to recover the fine that Malaysia just fined them and so on? Then you'll also see number 11. This was a German provincial government imposing environmental requirements on a coal-fired power plant. The investor sued for $1.4 billion, claiming violations of FET and expropriation, which are in the CPTPP investment chapter. And the German government settled. They couldn't afford to pay that. This is the German government who has more money, presumably, than the Malaysian government. So they dropped the environmental requirements. And the last one on that slide you'll see is a pending case for the Keystone Pipeline, which was tar sands oil from Canada going across the US via a pipeline. And the Obama government refused to give a permit for this pipeline because it would undermine their ability to deal with climate change. The investors sued for $15 billion, including the lost future profits they would have made if they could operate the pipeline after they built it, again alleging violations of FET and expropriation, which are in the CPTPP. Then Trump came into power and President Trump allowed the pipeline. So the Canadian investor dropped the ISDS case. But then President Biden was elected and he stopped the pipeline again. So now the ISDS case has restarted, again claiming $15 billion. And in fact, these kinds of cases by investors are often brought by the fossil fuel industry. It's the most litigious user of this ISDS system. Almost 20% of the known ISDS cases are by the fossil fuel industry. They win in the majority of cases, and the amounts that they win are almost 5 times higher, on average $600 million, than those in the non-fossil fuel cases. So you can see there are quite a few implications for climate change. So lastly, on the next slide, I just wanted to look at some of the other exceptions that might be available. Some people say, don't worry. Inside the CPTPP investment chapter, there's this article 9.16 that says, nothing in the investment chapter will stop a party from taking any measures for the environment, but it has that yellow highlighted part. The government can take any measure, so any laws or regulations, otherwise consistent with the investment chapter. So when I read that as a trade lawyer, what that means to me is this exception does not override any of those problematic provisions I've mentioned, like fair and equitable treatment or expropriation, because it only saves things that anyway comply with the investment chapter rules, those problematic provisions I mentioned earlier. So basically, this provision doesn't do anything. It's just there to make environment groups feel like, there's something environment, it's all okay. But actually it doesn't work as an exception that overrides those problematic provisions that I mentioned earlier. Then the CPTPP has a general exception for the environment that applies to chapters listed, but it does not apply to the investment chapter. And it generally doesn't in US free trade agreements, presumably because the US thought that the rights of foreign investors are more important than the environment. Then, as I mentioned earlier, ISDS cases occur for many things. They challenge, financial regulations and health measures like steps that governments have taken to deal with COVID, tobacco control, and so on. So the CPTPP has an exception to ISDS for tobacco control, but not for the environment. So obviously the CPTPP governments thought that ISDS could be problematic, for example, for regulation of smoking, so plain packaging of cigarettes or restrictions on tobacco advertising, and enough of a problem that those other safeguards I mentioned would not be enough, and so they had this exception to ISDS, but it was only for tobacco control and not for the environment. And as you might have seen in the list of CPTPP chapters, there is a chapter called the environment chapter in the CPTPP, but that does not have exceptions to the investment chapter. So it says blah, 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 many things about the environment, but it doesn't have any exceptions for the environment to the problematic investment provisions that I just mentioned. The CPTPP also has chapters on cooperation, development, and so on, but these are unenforceable and don't do anything to save Malaysian environmental measures. And in addition, the investment chapter is also enforceable through what we call state-to-state dispute settlement. So this means that if Malaysia does not comply with the investment chapter, for example, it requires technology transfer of environmental technology, or it caps the royalties that Malaysian companies have to pay, for solar panel technology to Japanese companies, where it doesn't have an exception in its annexes, it could also be sued by another CPTPP government, as well as an investor. It can be sued two ways. And if it's sued by another CPTPP government, again, it goes to an international tribunal. And here, if Malaysia loses, the penalty is that tariffs or taxes can be imposed on Malaysia's exports, for example, of palm oil or electronics, until Malaysia changes its law to comply with the CPTPP investment chapter, or Sabah changes its law to comply with the CPTPP investment chapter. And this also enforces the ISDS awards. So if, for example, Malaysia lost a case when the investor sues under ISDS, and it's supposed to pay $1 billion and it doesn't pay, then it can be enforced through state to state, and the home country of the investor, say Japan or Canada, could sue Malaysia under state to state and say, look, you haven't paid the $1 billion award to my company. We are going to impose tariffs, taxes on Malaysia's exports of palm oil or electronics or whatever, until Malaysia pays the $1 billion award. So this becomes very enforceable compared to an environmental treaty, for example. On the next slide, you'll see there's some links for further information. And here, I just wanted to give you some examples. Now we're on slide 8. Next slide. Thanks. Of how there has been opposition to ISDS since the TPP was concluded in 2015. So since then, basically, all the TPP countries have agreed to later treaties without ISDS. So that's RCEP, for example, and the US, Mexico, Canada agreement, or their governments have explicitly said they're against ISDS, like Australia and New Zealand. The Chilean government has been trying to suspend ISDS with various CPTPP countries. Peru agreed to stop ISDS with New Zealand. And in addition to, TPP countries rethinking ISDS, and it was Malaysia, of course, that led the changes to RCEP to exclude ISDS from RCEP. A number of other governments have also been stopping ISDS. So France, Netherlands, Poland, Spain have withdrawn from the Energy Charter Treaty, which had ISDS because of the way it prevents climate change policies. Italy withdrew in 2016. Developing countries have been withdrawing from treaties with ISDS, including Bolivia, Ecuador, India, Indonesia, Pakistan, South Africa, generally after they were sued for various policies and they lost, and they learned their lesson and withdrew. So basically, some may think that, look, even though this CPTPP investment chapter is problematic, well, maybe Malaysia can export more under the CPTPP, so overall the benefits outweigh the costs. But as I mentioned earlier, and that's the last link on this slide, actually Malaysia's trade balance will worsen under the CPTPP, and this was even shown in the study commissioned by MITI done by PricewaterhouseCoopers. So if there's no net benefits from the chapter where Malaysia would expect to benefit, the goods chapter, exporting stuff, it's not clear what the benefits are to offset the costs of other chapters in the CPTPP, like this investment chapter, the intellectual property chapter, the government procurement chapter, and so on. And of course, Malaysia could withdraw from the CPTPP if it gives notice in writing and then it takes effect 6 months later. So Malaysia could choose to withdraw, tomorrow if it wanted, and then 6 months later it would be out. So on the last slide, of course, it's up to an investor whether they sue or not. Some may choose to preserve the relationship with the Malaysian government. They want to get permits so they don't sue. And maybe the government wants to assess whether this chapter constrains Malaysian environmental laws and policies or plans that it might have, or its 12th Malaysia Plan goals on the environment and so on. So maybe we can, again, take questions. I think there's a lot. And then after this, the second half is how these provisions apply to Malaysia's environmental laws and policies. And then there can be some more general discussion, I think, after that. Thanks.
Yeah, sure. There's a lot happening in the chat box, so I hope we have enough time to handle all 8 questions all in one go. Nevertheless, since we are still fresh on the ISDS, I would like to take 2 questions as one from Huai Mei Yong. The examples of ISDS cases given an impression to allow the investors to pollute the host countries. Is there any chapter in CPTPP to help the host countries in protecting and conserve the natural resources and environment? And additional question from Pui. Yes, pro-FTA folks have argued that these free trade agreements require signatories to enhance the environmental and labor laws in order to enjoy benefits of FTAs. Is that right? So 2 questions in one go. Sanya.
Yeah, so it's good to group those 2 questions together. So there is an environment chapter in the CPTPP, and I give a link in the second last slide to the text of the CPTPP. You can get it on the MITI website. And you'll see it requires countries, including Malaysia, to do various things for the environment. But the problem is that that chapter does not operate as an exception to the investment chapter. So when Malaysia tries to do things for the environment, it could still be sued under the investment chapter by foreign investors who say, look, you are reducing my profits, expropriation, you are harming me with this new or amended law or regulation, you are violating fair and equitable treatment. So yes, there is an environment chapter that says do nice things for the environment, but it doesn't save Malaysia from the investment chapter, which is enforceable by the investors suing for unlimited money or by other governments suing, with tariffs on your exports if you don't comply and you lose the case. So the same for labour. There is a labour chapter. It says, do nice things for workers' rights. But again, if the government takes steps to protect workers, it could again be sued under the investment chapter. So there's a famous case under another treaty where after the Arab Spring, the Egyptian government said that they were going to raise the minimum wage, in recognition of all the Arab Spring concerns. And they got sued by a French company, I think it was Vivendi, who didn't want to pay the higher wages under ISDS, saying, you're reducing our profits and so on. So labour rights can definitely also be challenged under the investment chapter, even if there is a nice labour chapter in the CPTPP which says do nice things for workers. Again, it's not an exception to the investment chapter and these problematic provisions.
Yeah, still on the topic of ISDS, Pui Yi asking a question, are ISDS proceedings publicly held? Was there any CSO campaign supporting the government against the investors, calling for corporate accountability? The general public should be supportive of such campaigns, and it would be bad marketing for the investors, wouldn't it?
Yes, so that is a good question. So under the CPTPP, from memory, I think these proceedings are public. under a lot of the other treaties, they are not. Under a lot of the existing investment treaties, it's not public which government is sued by which company for what the outcome is, how much the investor won, all that kind of thing. But where it is public, you're right, there can be public pressure. And I think from memory, there was one where Bolivia privatized their water and it all went wrong and they had to renationalize it because it was too expensive or whatever. And the investor sued. And there was such a public outcry about how the investor could sue about this that in the end, I think they got $1 in damages. But that only, of course, works for companies that are subject to public pressure. And I mean, this is the usual campaigning thing, right? Where, a Nestle boycott works because, it's consumers who buy Nestle products. But if it's some kind of widget company that makes inputs for another company, it's harder for there to be a mass consumer boycott because it's not making a consumer product. So it's rare. I mean, given the number of ISDS cases, it's rare that kind of public pressure has successfully dissuaded investors from taking these cases. And you can see from the links that I put on the UN website, on the database of these cases, they're in all kinds of sectors. And they're pretty shameless, some of these cases. They're about COVID measures, they're about financial regulation in a financial crisis, they're about after the Arab Spring. And part of this is because of the role of the law firms. They are doing what we call ambulance chasing, where the law firms go to the foreign investors, for example, after the Arab Spring, and they say, have you had problems because of the Arab Spring? Let us sue these governments for you. Don't pay us any money. If you win, pay us 10%. And so these law firms are generating cases, and they were doing it during the COVID pandemic. They were holding all these webinars for foreign investors saying, have you been harmed by these lockdowns? This is how you can sue the governments. Let us sue for you. Don't pay us any money. Only pay if you win the case. And it causes a kind of a perverse incentive because there have been cases where the investor wanted to settle with the government to preserve the relationship. They have to keep operating in this country. So they settled, I think, again, an Egyptian case for like $5 million. And the investors' lawyers sued their own clients for settling for too little because the law firm was getting a cut of the damages. And they said, you shouldn't have settled for 5 million, it should have been 10 million because then the investor would have got twice as much. So yes, ideally with ESG and so on, this would cause some naming and shaming and discourage companies, but there are a lot of kind of incentives working, and now there are vulture funds and third-party funding where they're kind of packaging up these ISDS cases and selling them as financial products. So there's a lot of money in the system. That means that it's still going on. And a lot of the ISDS arbitrators, they're ad hoc. So they act as a judge or an arbitrator in one case. Then in the next case, they act for the investor, quoting their own decision in the earlier case where they found that the government was liable and, $1 billion should be paid by the government. So there's all kinds of conflicts of interests. For example, there's a famous Swiss arbitrator who was on the board of directors of the parent company of the investor suing in the case. She did not disclose it. The investor won. The government, Argentina, found out and appealed. And on appeal, they said, oh, this case has gone on so long. We feel sorry for the investor. We trust the arbitrator to do the right thing. The investor still wins. And she went on and did that in another case. So it's a very kind of shameless system. You would think there would be ESG and CSR and so on, but not really so far. And one of the links I put on the slide by Corporate Europe Observatory has these kinds of examples.
Right, there's a question from C. Peng. Can a party withdraw from CPTPP even after ratification? Why didn't Canada withdraw from CPTPP since it had gotten sued by investors for doing the right thing to protect the environment? Yeah, so any country can withdraw with notice in writing, and then it takes effect 6 months later. It's quite a big deal often to withdraw. So, the famous one is the UK withdrawing from the EU was Brexit. Of course, that was a more kind of complex treaty, and it was a customs union. There was a whole lot of other things it was withdrawing from. And so it wouldn't be such an impact if Malaysia withdrew from the CPTPP because Malaysia already has free trade agreements with all the CPTPP countries except I think Canada, Peru, and Mexico, and those are pretty small recipients of Malaysian exports. And anyway, Malaysia can export to them under World Trade Organization rules where they don't really impose very high tariffs on Malaysian exports anyway. And as I said, the imports into Malaysia increased by more than the exports under the CPTPP. So, Malaysia's trade balance would actually improve as the Cost Benefit Analysis Commission by MITI even admitted.
So it's not a disaster if Malaysia withdraws, because what happens is Malaysia continues to trade as it did, in August this year with all the CPTPP countries. And some of the CPTPP countries like Australia, New Zealand and Singapore have already removed their tariffs on 100% of Malaysian exports under existing free trade agreements before the CPTPP. So, and why didn't Canada withdraw? Yeah, this is interesting because Canadian governments, including the current government under Trudeau, have been quite pro-ISDS for the Canadian mining companies who like to sue. And they're quite problematic investors. There was a famous example, I think, in Mexico where there were community protests against a mine, and the mining company employee went to the protester's house and shot him dead. The Mexican government temporarily closed down the mine because obviously it's controversial, and the Canadian mining company was going to sue under ISDS for the lost profits they would have made when they murdered the protester. So Canadian mining companies are quite problematic, and the Canadian government historically has wanted ISDS so that their mining companies can continue to sue host governments who are trying to regulate its mining companies. So they don't care so much about getting sued themselves, they just want to protect their mining companies abroad from governments regulating them.
Okay, next question from Sonia. There are some provisions in the chapter which provide safeguard for environmental protection. Governments can take measures to ensure investment activity in its territory is undertaken in a manner sensitive to environment, health, and also regulatory objectives. How should we read this?
Yeah, Sonia, I'm not sure if you're referring to the provision I showed on slide 7, and maybe the team can kindly put that one up again in the investment chapter, Article 9.16, because that provision does say, yes, you can take measures sensitive for environmental reasons, but the measures must be otherwise consistent with this chapter. So when I read that as a trade lawyer, it means your laws and regulations must anyway comply with the investment chapter, including the provisions that I just mentioned, fair and equitable treatment, expropriation, and so on. So it's not an exception. Yeah, thank you. If you look at slide 7, I think that might be the provision Sonia is referring to. Maybe Sonia can confirm in the chat if that's the provision she had in mind. If you go back to slide 7, I think that's slide 6 or 5. Go forward a few. There's a little page number on the bottom right corner of the slides. Looks still like slide 5 to me. You can go forward a couple of slides. Anyway, yeah, so that provision, maybe Sonia has confirmed, no. So that provision, which says sensitive to environmental reasons, is not, I don't think as a trade lawyer, is not an exception to the investment chapter. It says you can do things as long as you comply with the investment chapter, which means it doesn't override the investment provisions that have been so problematic for environmental regulations, as we saw in some of those cases, which were under other treaties, but were about the same provisions like fair and equitable treatment and expropriation and so on. So that provision, as I understand it, has just been put in to try and persuade environmental groups, don't worry, this chapter is fine, because under the Obama administration, they needed the support of the environment NGOs to get this thing through their US Congress. And some of the environment NGOs were fooled by it. And some of them who had lawyers realized, actually, this is not an exception that overrides these provisions in the investment chapter that have been so problematic for environmental laws and policies around the world in other cases. So I don't know if that answers the question. Sonia, if that wasn't the provision you're referring to, please give me the article number that you are referring to in terms of exceptions in the chat. Thanks.
I would like to go back to JP Vincent's earlier question, posted somewhere around 8:40. How is Malaysian MITI, taking this matter up? And I would like to extend a bit. I would like to add on to this question, because I just want to understand the dynamics. Why is it the government, the ministry in particular, is so confident in taking this up, and it is already being ratified? I heard that the CBA. So what's your take on the CBA itself?
Yeah, so MITI, of course, was responsible for negotiating the investment chapter in the CPTPP, and they were the chief negotiator responsible for trading off across other chapters. But as I understand it, if the Malaysian government is sued under ISDS, under the CPTPP or other treaties, it's the Attorney General's chambers who has to defend. So MITI negotiates, but they're not the one who has to defend the case, and it's not their budget, presumably, which gets used if Malaysia has to pay $1 billion, right? So it's kind of not their problem. So the Attorney General's chambers may be more concerned about ISDS, and I think the Attorney General chambers were more involved when it was the Malaysia-US Free Trade Agreement negotiations. Then, of course, MITI has, as you say, commissioned another cost-benefit analysis by PricewaterhouseCoopers, and there's a number of problems with it. It has very kind of, I guess it was narrow terms of reference, so it doesn't look at things like the impact, say, on food sovereignty or food security. It doesn't look at the impact of a lot of these investment chapter provisions we mentioned. And even though it itself admits that the trade balance of Malaysia would worsen because the imports would increase by more than the exports, it goes on to kind of do this computable general equilibrium modeling, which it uses to say that, don't worry, the gross domestic product of Malaysia, the economic growth will increase and Malaysia will get more foreign direct investment. But the modeling that it uses has been heavily criticized, including by economists. And they themselves say that this model is based on intuition, and it's based on, let's assume the CPTPP says XYZ, which doesn't actually reflect what's in the CPTPP text. You know, it says, let's assume the CPTPP cuts non-tariff measures by 50%, but actually the intellectual property chapter increases non-tariff measures. So it's based on a hypothetical model that doesn't match the text. And then it assumes things like, let's assume full employment. So any farmers who lose their jobs because of a surge of imports can automatically find jobs in the exporting sector. Let's assume that there's no tariff revenue loss, even though there will be, I think, 1.6, what is it? Was it $1 billion in tariff revenue loss a year under the CPTPP. So let's assume all the way, 1.6, where is it? $1.6 billion in tariff revenue loss a year. Let's assume that away too, and assume Malaysia can make that up through other taxes, even though the International Monetary Fund notes that it's very difficult, even for middle income countries, to make back more than 60% of that lost revenue. So it has all these kinds of unrealistic assumptions. And it's been so heavily criticized, this computable general equilibrium modeling, that economic journals will no longer publish the results of it, you know, the peer-reviewed economic journals. But nevertheless, that's what the MITI commissioned cost-benefit analysis uses to say there's going to be great economic growth and foreign direct investment all coming from the CPTPP.
The projection is not all that big after all, you know.
Yeah, and it's not based on any realistic assumptions. It's based on intuition, something that is not actually the CPTPP text, and then a whole lot of economic assumptions that are not real life, like let's assume full employment and, you know, there's no change to the tariff revenue and all these other things.
That we can make do without CPTPP.
Yeah, so I mean, without the CPTPP means Malaysia goes back to what it was doing in August this year. It was exporting to all these countries. Malaysia already has free trade agreements with all of them, except for Canada, Peru, Mexico, and those countries get, I think, less than 1% of Malaysia's exports. Let me just look it up. And as I was saying, you know, even though you export a little bit more to Canada, in fact, the imports increase by even more, so Malaysia's trade balance worsens because, you know, Malaysia removes tariffs on 100% of products, whereas, you know, I think Japan only removes tariffs on 95% of their products, and, you know, Malaysia's starting tariffs are higher, so it's a bigger drop. So that's why there's a bigger surge in imports. And so, yeah, if we look at, you know, what are these new markets? And Malaysia already, as I was saying, 100% of Malaysian exports already enter tariff-free into Australia, New Zealand, and Singapore. And yeah, Mexico gets 1% of Malaysia's exports, Canada gets 0.37%, and Peru gets 0.06% of Malaysia's exports. And Malaysia already has free trade agreements with all the other CPTPP countries, like 8 free trade agreements with Vietnam. So this would be the 9th free trade agreement with Vietnam. So how much new exports are you going to get to Vietnam under this? And Malaysia can already export under WTO rules to all those countries.
So let's take the last question from C1. We just recently pops up in our chat box. In Malaysia, can private companies being sued under CPTPP or government being sued, but private companies are responsible to pay?
So only the government can be sued under the CPTPP. It can be sued in 2 ways. One, by the foreign investor for unlimited money, like $1 billion or $6 billion, and one by another CPTPP government, in which case, if Malaysia loses, the punishment is, you know, tariffs on Malaysian exports until it changes its laws to comply. The CPTPP does not allow governments to sue private companies. It's only governments who can be sued. And remember, for ISDS, it's the national government that gets sued, even if it's the state or local government who has violated the CPTPP investment chapter, and then it's a question of whether the national government can get the money back from Sabah or Perak or whichever state violated the CPTPP investment chapter, for example, by withholding federal funding from them.
Right, so I think we have addressed all the questions being posted on our chat box. So maybe in conclusion, Sanya, what are the key takeaways from our session today?
So Malaysia has ratified the CPTPP. It is in force. It does have this chapter which gives strong rights to foreign investors to challenge Malaysian environmental laws and policies. It's up to the Malaysian government now what it does. Does it stay in the CPTPP? Does it try and reduce its exposure to ISDS by signing these kinds of side letters with other CPTPP countries to remove ISDS between them? Does it withdraw from the CPTPP, which it can do, by sending a letter and then it takes effect 6 months from now? So it's a question of, it's kind of up to the Malaysian government and how much will the CPTPP's investment chapter restrict its ability at all levels, federal, state and local, to implement its environmental laws and policies, for example, the things that Evelyn Ter mentioned. And I think there's a question about the next session, which will be the impact of other CPTPP chapters on the environment, not the investment chapter, on things like biosafety, biopiracy, and so on. So I think the organisers are going to give a link to that for the next session.
Yeah. So before we adjourn, I would like to invite Leela. Maybe there are quite a number of questions regarding our next session on the 19th. So if we can share some input, because I think our participants today already asked and registered their interest in attending our 19th January session.
Yes, we'll be posting the link on chat, and I think Siti will be sharing the poster now. It's on the like we said, it's on the 19th of January, and it'll be from 8:15 to 10 p.m. Like today's session. So we will, for all those who have registered for this webinar, we will also send you an email with the link so that you can register for it as well. But I think Chin has also shared it in the chat, so you can all register now as well. Thank you. Thank you everyone as well for all the many questions and the many thought-provoking questions. And I think there's a lot of anxiety about the CPTPP, and we look forward to the second webinar with Sanya on the other chapters and how it affects the environment. Thank you, everyone. And we look forward to seeing all of you on the 19th. And thank you very much, Syed, for being the moderator for our session today. And we look forward to you coming in again as the moderator for the second webinar.